Chapter 15, Criminal Law. Criminal law is set up to protect society, so it's an offense against society, where civil law is the idea that we want to protect the individual, corporation, government, doesn't matter. So a plaintiff in a criminal action is always the government. So here in Indiana, it would be the prosecutor's office. So a prosecutor or deputy prosecutor is going to bring the action. In a civil action, it's just you, me, the corporation, suing someone for monetary damages. Criminal law, the idea normally of putting somebody in jail or prison, sometimes there'll be fines. So with that in mind, you could have the same particular activity that is criminal and civil. So you might have the government prosecuting someone to punish them, and you might have an individual that wants to recoup monies, to get monies for their individual damages. Two different actions. Now, your chapter 25, in your text talks about assault. So if we say assault, the author is using that term incorrectly. How is the author using that term incorrectly? Well, states like Indiana and traditional common law, meaning Old English law, would say an assault is just a threat of an injury to an individual with the present appearance to be able to carry it out within some reasonable time. So it isn't the actual hitting of someone, and that's what your author uses, the idea of assault. They say slugging someone is an assault. Well, technically, the author is right if you're in Massachusetts, Texas, or Washington State, because Washington State doesn't use the traditional term that we call battery. Battery can be a civil and or a criminal offense. Under criminal law, the battery is what? Well, it's the touching of another human being without permission in a rude, insolent, or angry manner. Keep in mind, it's an or. That's what a battery is under criminal law. And then we have society through the prosecutor's office wanting to punish the individual that committed the battery. So in some sovereigns, we still have the Old English aspect where you could have an assault, someone saying, I'm going to hit you if you don't stop doing something. And with that in mind, that we would say is an assault. Except, again, if you're in Massachusetts, Texas, or Washington, and a couple of other states. But if I actually hit the individual, here in Indiana, that would be a battery. And in most of our states, that is a battery. So the terminology changes in some sovereigns. We don't use the exact terminology in every sovereign, but the principles are the same. So, at least generally the same. Now, your author also talks about costs of prison. So the punishment aspect of individual. On page 225, the author says $10,000 is the idea of what it costs to incarcerate someone in prison for a year. Well, that isn't quite correct. If you take a look at this particular article, it talks about the cost of incarceration. So we can have up to $49,000 on average in some states that it costs to incarcerate an individual. That's a California price. Now keep in mind, if you have an older individual, someone say my age, the average cost is $150,000. But since we have more younger individuals being incarcerated, it's less on average when we take the older and the younger together. Now, with that in mind, I always like to move back to the sovereign that I'm in. I used to teach in Washington State. I've taught many courses in California. I've been teaching full-time in Indiana for, this is my 23rd year. With that in mind, I've always used the state I'm in as an example. So Indiana, their cost on average for incarcerating someone is $21,500. Still significantly more expensive than your author throwing out the $10,000, but significantly cheaper than the average in California, that's $49,000. So just kind of an idea of those costs of punishment. A little further, if you look at this particular article, a little bit older article, so we might inflate these dollar amounts a little bit, but what I want to target is this aspect of the monetary amount for the death penalty. So this particular author is tagging the cost for legal costs and all of that to have someone put to death at over $1 million or approaching $1 million. It depends again on the particular sovereign, but generally speaking, we think that's a cost of what it would take. So you equate that to how much it costs to incarcerate someone, how old they are, and you could do that break-even analysis in regards to whether putting them to death or a certain number of years in prison, like life in prison, which is the best. We don't tend to do that in law, but it could be done. Now, here's a particular article that deals with the idea of sentencing time periods and along with costs of that. Since we're dealing with economic issues, what I want you to see is that this state, Indiana, is trying to save money on what? Well, prisons. So they're looking at this potential $1 billion savings. That's a significant amount of money. So with that in mind, things that can be done to help reduce the cost. Unfortunately, some of those things tend to be reducing educational opportunities for individuals that are incarcerated. And we'll talk about how those type of things can create additional problems. So when we think about that, it ties in to why do we punish. So with that in mind, this particular information doesn't deal with psychology or sociology. It deals with the legal principles of why do we punish. Now, natural persons can be punished, meaning put in prison or jail, but corporations can't. Well, wait a minute, a corporation is just papers, right? You might have your articles and corporation bylaws, all of that. So this big stack of paper, well, you could physically put that in a jail or physically put all those papers in a prison and say that they have been incarcerated, meaning this artificial person. Well, the reason we say that can't be done, you can't put a corporation in prison. You can put their officers and their agents and their employees, but not the corporation, not this artificial company or artificial person. And the reason you can't, even though you physically can, is because of these reasons in regards to why do we punish. It doesn't satisfy those reasons. So we have four theories. They can be individual in regards to a punishment, or you can have all of them tie in. So I'm just going to start with retribution. What do we mean by retribution? Well, in this instance, it's the government getting retribution. So it isn't like my two boys when they were growing up. If one of them would get hit by the other, what would the one that got hit do? They would go back and hit the brother. The idea of an eye for an eye, a tooth for a tooth. Okay, that's individual. That's been taken away from us. It's government now, and we use the example through the prosecutor's office, that uses this legal form of revenge, the punishment for that, in regard to the activities or inactivity that a particular individual has done. Because we can have crimes because a person didn't do something. So an example, when my boys were really young, if I didn't take them to the doctor to have medical tests and they died, and I had plenty of time to take them and a reasonable person would, then my inactivity could hold me criminally responsible for neglect of this person under my control, this child, my child. Okay? So what about restraint? A second aspect of why do we punish, and really the justifications for punishment. Restraint is just putting them physically in the prison or the jail so they don't have freedom I think of that, and again, I like to use analogies. That's how attorneys are taught, is going back to my two boys. They were fighting. Remember, I used the example of one boy hitting one, the other hitting him back. So in this instance, I'm punishing both of them. I'll put them on the couch, one on one end and one on the other. Well, not a very good restraining because they start kicking each other. So, meaning putting their feet on the couch and kicking at each other. So I put one now in one bedroom and one in another bedroom. A restraint, trying to keep them away from each other and away from things that they would want to do. Okay? So we deal with that as restraining the individual, keeping them out of society. Now, deterrence. That's the idea that we want to frighten the individual, and not just frighten the individual, but frighten others that might want to do the same thing that the individual we're punishing did. So if by chance only one of my two boys hit the other, then I want to punish one of them so that boy maybe won't do the same thing again, and so his brother won't look to do that. Here's another example. A student perspective. I had invited in a few years back a Superior Court judge to be a guest lecturer when I was dealing with constitutional law. And with that in mind, one of the students was dozing off towards the back of the class. Well, this particular instructor, now an instructor, actually his job was a judge, he picks up a hard eraser and throws it at the student. Luckily, he misses the student. But what does that do? It wakes that student up. Okay? So that was what his goal was. But unfortunately, that's an assault in many states, right? Because he tried to injure the particular individual. Now, if that eraser would have hit the individual, even though it might not do any significant harm, that's still a battery. It's rude to do that. Now, change that a little bit. Let's imagine that I see this particular individual do that activity, this judge, and I'm thinking, okay, that's what I'm going to do in class now. When I have someone falling asleep or sleeping, I'll take this big, thick book and I'll throw it at them. Imagine if I hit that individual. Well, could put him in the hospital, but if it doesn't put him in the hospital, they probably won't fall asleep anymore in my classes. And other students will try really hard not to fall asleep. So from my perspective, that would be a success. Now, let's imagine other faculty members hear about that and how I never have students falling asleep in my classes. They might start doing the same thing. Is that good for society, getting hit with books? No. So, by hitting the individual with the book, the government wants to what? Punish me for a battery. Now, the individual under civil law could bring an action if they suffered injury, meaning had to go to the hospital, lost a tooth, maybe it cut them and they had to have plastic surgery. Okay, that's under civil law. But under criminal law, the government wants to punish me, and what else? Well, deter others, so keep other professors from doing the same type of thing. So in this instance, the deterrence, very useful. We also use deterrence by saying that if you commit particular offenses, it's a long time period that you have to serve. So the more severe the particular offense is, the longer time in prison that a person can be incarcerated. That's to what? Well, it's to deter me from doing those things in the future, but also to deter others. Now, reformation, the idea of reforming individuals, making them good members of society. Unfortunately, putting individuals in prison or jail, it's hard to imagine that that is successful in regard to reforming individuals. Why do I say that? Well, think about when you were growing up, your parent or parents may be telling you that they don't want you associating with or being friends with certain individuals. Why? Because they're afraid that you will mimic, copy, adopt those particular bad things that these individuals, friends, acquaintances, whatever, are doing. So with that in mind, they don't want you to act like these individuals. So just being around them can cause a change in our behavior? Well, when we put people in prison together, we restrain them. Remember, one of the justifications for punishment, we put them with what? A large group of other individuals that aren't conforming to societal norms. So we call those individuals deviants. And now we have deviants crowded together, and they can learn from each other, or their behaviors can become what we'd say worse. So with that in mind, some potential problems with the types of punishment that our society uses. Now, your chapter also talks about this idea of necessity. On page 224, it deals with that. So what I have in front of you, if you see this particular thing, is right from Black's Law Dictionary, and it talks about necessity. Irresistible compulsion is what I like to think of, where in limited instances, that might be a justification. So what do we mean justification? Well, under the criminal law, we have this idea that there are excuses and justifications for what we do. So let's imagine someone's murdered. Will a person go to prison for that? Well, it depends. You take the life of someone, do you have an excuse that the law says is permissible, or a justification? So let's imagine that someone's holding a knife to my throat, and while they're doing that, I get in my pocket and pull a knife and stab them, and they die. That's self-defense. Now, think about a police officer or a SWAT team shooting a particular individual that's holding people ransom. If it's the individual that is causing the particular criminal activity by holding these individuals, kidnapping them, this criminal confinement, if they're doing that, there might be a justification for the taking of that life, of that alleged criminal. We have to say alleged because they're not convicted of that particular offense. Why? Because they died. So a judge or jury hasn't convicted them of it. Or we could have a soldier doing what they're responsible for in their activities in the military, and they comply with orders, and they're doing what society thinks is reasonable, and they take a life. That's not an illegal killing of another individual. So with that in mind, an excuse or justification. Your author talks about on page 231, murder in a lifeboat situation. The taking of life is one of those things that we really have difficulties justifying. I just gave you a few exceptions, but in most instances, not a justification for it. So who's going to decide that? If it's tried before a judge, the judge will. If it's tried before a jury, the jury will decide if there's an excuse or justification. The idea of necessity, as your author talks about. Now, what I'm going to do is go through some examples. So let's, before we do that, talk a little bit about burdens of proof. Now, your author on page 225, 230, and 232 talks about burden of proof. The idea that under criminal law, the plaintiff, meaning the government, the prosecutor's office, has the burden of proof. They're bringing the action. They're the plaintiff. And what is their burden of proof? Beyond a reasonable doubt. Beyond a reasonable doubt. Some people will say that's 100%, some 99%, but it's a very high percentage if we want to quantify it. Now, for a civil action, meaning an action in which the individual brings the lawsuit, the individual's the plaintiff then just has to prove what? A preponderance. Just more than 50% is all. And so major difference. So we could have a criminal action when it's alleged to be a criminal action like murder or battery or something else under criminal law where the particular alleged criminal isn't convicted. Why? Because the jury isn't convinced beyond a reasonable doubt that they committed the particular alleged crime. But a civil action could hold them responsible for the damages that were caused. If we think about a murder aspect, being criminal, the civil aspect is wrongful death, and it's only what? A preponderance, just more than 50% chance that the person did it. So when we're talking about that, that's a very low threshold, just more than 50% when you compare it with beyond a reasonable doubt that many parties think of as 100%. So big, big difference. Now, let's use some examples of criminal activity. And since Purdue is in Indiana, we'll use Indiana's laws as an example. If we're in Washington, we'd use Washington laws or California. So some states don't use the term murder. They might use the term manslaughter or homicide, or in some instances, they'll use the term murder, and then lower level offenses will be murder in the first degree, well, that's the highest level, murder in the second degree, the lower level murder in the third degree, or maybe even a murder in the fourth degree, where Indiana deals with it as murder, and then the second aspect, the lower aspect, is voluntary manslaughter. The third lower aspect is involuntary manslaughter. So I always liked it when it was easy. 1, 2, 3, murder in the first, second, and third, rather than changing the terms like Indiana does. But since we're using this as the example, that's what we'll stay with. So, murder, knowingly or intentionally killing another human being. For major offenses, meaning offenses that require significant prison time, normally we say they can't be accidental. You might have to serve lesser time if it's accidental in regards to criminal activities, but in the activities that are a person's going to be put in prison for a long period of time, we normally say it needs to be knowingly or intentionally causing an action. So in this instance, murder has to be knowingly or intentionally killing another human being, not accidental. And then down at the bottom it says commits felony murder. Well, really, murder in this state is second degree murder. Felony murder, even though we have under criminal law this idea of felony law, something's a felony and something's a misdemeanor, the legislature isn't using that in regard to the terminology. They're kind of mixing and matching, because if we talk about felonies, those are activities, at least under common law, where a person will be incarcerated for a year or more. Misdemeanors deal with an instance in which someone would be incarcerated for a year or less. So we have this overlap at a year. And the aspect of common law, meaning Old English law that most states follow, would say that jail is up to a year. If someone has to serve a longer time period, then we put them in prison, which is a year or longer. It follows that felony aspect and misdemeanor aspect. Indiana, a number of years back, changed that. So we have a felony that you can be incarcerated in prison for half a year. But we'll go through those examples. The idea is what's common, but each state, as its own sovereign, has the right to make modifications, change. They don't have to follow Old English law, even though many of them do. So felony murder in this state, first degree, meaning a person can be put to death for it. If it's just murder, then, and I say just, well, that means you can't be put to death for it. But what makes something a murder? Well, knowingly or intentionally killing another human being, and what we need is this aspect that it has to be premeditated. Even though it isn't in the statute, that's what the courts require. What does premeditated mean? It means planned out. So let's move to this aspect of a particular murder that isn't planned out, or at least it's alleged that it isn't planned out. We call that a voluntary manslaughter. It's still knowingly or intentionally killing another human being while acting under what? Sudden heat. Well, what does sudden heat mean? That just means not premeditated. Under Old English law, we used to, 300 years ago, put people to death if they commit a murder. And then the courts decided to modify that. Why? Because we have an individual that kills his spouse. Why does he kill his spouse? Because his spouse is having an affair, and he catches the two together at the same time. And so the courts use this aspect of heat of passion. Catch that? Heat of passion Okay, they've modified it today to call it sudden heat. Why? Because there might not be any passion involved. Let's imagine that someone's at a bar and they're drinking and they have a mug and someone says something to them that they don't like and they hit the individual with their mug, a beer, and the individual is hit in the head and they die. Well, that's not a murder, it's not premeditated, it's happening instantly. So, but there's no passion involved. So the Old English aspect wouldn't fit, but in American law we've modified that to say sudden heat, meaning not premeditated. That's all we're talking about. And as you can see, this has a lower penalty. It's only a Class B felony, where the murder is a Class A felony and can, if it's a felony murder, cause someone to be put to death. So let's take a look at another example. We'll go down and we'll say voluntary manslaughter. Now you can also see criminal trespass, but we'll hold off on that. What's voluntary manslaughter? Well, it's a lower level offense again. So remember we talked about first degree, second degree, third degree. This is more like in Indiana, fourth degree. Why? Because felony murder is first degree, be put to death. Murder would be like a second degree. Voluntary manslaughter would be third degree. And then involuntary manslaughter, if we were using numbers, would be, and some states do, would be this aspect of a fourth degree. So it's just a lower level offense. Well, as a lower level offense, the penalty is less. And as you can see, it's a Class C or a Class D felony. And I'll show you in a minute what all that A, B, and C, and D means. But with this in mind, I just want to go through this example of voluntary manslaughter. Okay, catch how this is defined. And this is defined by the legislature. Those numbers in front of it are the Indiana state codes, the acts, the statutes, all meaning the same thing. That just tells you where you can find it in this state. So reference number. So a person who kills another human being while committing or attempting to commit, okay, you didn't hear this willful or intentional, this idea of knowingly or intentionally killing another human being. So this, you don't have to intentionally have done it or even knowingly have done it. So let's use the extreme example. They talk about this aspect of some inherently dangerous activity, or this idea of driving a vehicle and you cause the death of an individual. So we'll try both. Let's imagine that you're playing Russian roulette. So you put one bullet in a pistol that has a cylinder that spins, and you spin that around and you shoot it at the other person. They don't die because no bullet comes out. And the cylinder has 6 holes for bullets to go in. There's only one, so it's a 1 in 6 chance. Now the other person spins it and aims it at you and shoots. The bullet doesn't go off. Now you spin it and aim it at the other person, and guess what happens? The bullet goes off. Okay, so that's an inherently risky type of activity. So with that in mind, we have, or maybe could be convicted of involuntary manslaughter for that. But if you look at this aspect of involuntary manslaughter, you can see with the third one, it says, however, if the killing results from the operation of a vehicle, the offense is a Class D felony, meaning the lowest offense in regard to felonies, which is a half a year to a maximum of 3 years that the person would spend in prison if convicted of involuntary manslaughter. So that could be that a person is intoxicated and collides with another car and their passenger dies, or someone in the other car dies. Then this is the traditional aspect that the prosecutor's office charges with the party, this involuntary manslaughter. Okay. Now let's move quickly to what we have in this sovereign. Now this sovereign again is distinct, right, because it's one of our 50 states, but it's not the same as other sovereigns. The time periods are our own legislatures deciding how long they want to incarcerate parties. So with that in mind, we look at these time periods. The unfortunate part in regards to why do we punish is because most criminals don't know these time periods for particular offenses. So they don't know that if it's voluntary manslaughter, it's a Class B, 6 to 20 years. They don't know that if it's, let's say, this driving situation and they're intoxicated. It doesn't require intoxication, but usually that's what a prosecutor's office uses. If the person isn't intoxicated and they take a life, normally an action isn't brought, but it can be. But in that instance, a Class D is only a half year to 3 years for the taking of the life of another. And those are ranges. So if you've never committed any other offense before, any criminal actions, you're a good member of society, you show remorse, meaning you feel sorry for it, it's usually on the lower end. So if it's a Class D, you'd normally get a half a year. If you're an individual that's been bad, use that example, you've had lots of prior offenses, convictions, then it's the higher extreme, that 3-year time period. But when we talked about murder, it can be 45 to 65 years. Okay. Now, remember the Class B, the voluntary manslaughter, 6 to 20? And these numbers won't be on an exam. The idea for these numbers is just to let you know how we deal with this punishment aspect. And the more severe the particular offense, the longer the person can be incarcerated for. So that's the idea of these time periods. Well, I should talk a little more. As you can see, the felony aspect, a number of years back, Indiana used to have for a Class D a 1 to 3 year time period, right? That way they would fit under common law. They changed it to a half a year. So overlapping significantly with misdemeanors. As you can see, the 3 classes of misdemeanors, A, B, and C, not more than a year for a Class A, not more than 180 days, about a half a year, and not more than a couple of months for a Class C, the 60-day time period. So we have a lower time period that the person's going to be incarcerated for. Now, let's make this a little bigger and talk about then criminal trespass. The next one, aspect of Indiana statutes. Criminal trespass involves what? Well, we read it. A person who not having a contractual interest in the property knowingly, not accidental, but knowingly or intentionally enters the real property of another after having been denied entry by the other party or their agent, his agent. So in this instance, what does that mean? You don't accidentally wander onto someone's property. You knew, you intentionally, right? Knowingly or intentionally. And what's real property? Land or anything attached to it for its real life. So going on into a farmer's field, on a ranch, going into someone's home, a commercial building, a garage even, right? Or just cutting across someone's property. All could be criminal trespass. So when we look at that, we say, how does that fall? What happens? Well, in this instance, it says not having a contractual right. You could own the particular land. So you have a deed to the real property, the house, the commercial building. You have a contractual right. You have people that lease property. They have a contractual right. You have individuals that are invited in, potential customers and customers. But let's change this a little bit. Let's imagine that you're a student in a class, not an online class, but a class. You're in the classroom. And let's imagine, for whatever reason, I tell you to leave the classroom, to get out. I don't want you in my classroom today. With that in mind, you had a contractual interest. You have a contract with Purdue, if it's an in-class type of lecture, to be in that classroom at that particular time on that particular day. But under the contract, contracts relate not just to a few words, but relate to all of the aspects, and we have policies that students are supposed to be aware of that says the faculty member has control over the classroom. And with that, it goes into detail that a faculty member can require a student to leave. Now, if the student doesn't think that's acceptable, they can appeal that to the supervisor of the faculty member, even to an appeals committee made up of students, administrators, and instructors, but they have to comply at that time. If they don't, the particular professor can use their cell phone, or if there's a phone on the wall in the room, and they can call security. Campus security will come. They can be arrested, the student, for what? Not leaving the room. Normally, campus security will ask them to leave. If they won't leave, then they'll be arrested. Why? Because they no longer have a contractual interest in being there. No different than, let's imagine you have a party at your home, whether it's a dorm, an apartment, a house, and you invite a lot of people over, and now it's 4 in the morning, and you have class tomorrow. Everybody else, it's Thursday night, they don't have class, but you have class on Friday. So what do you want to do? Well, you want to get a couple of hours sleep before, well, more than a couple hours hopefully, before class starts, so you ask the few people that are left to leave. If one or more of them will not leave, what have they done? They've committed a criminal trespass. So with that in mind, what can you do? You can ask them again. And now they say, no, we're having too good a time. We're just going to stay here. So if they decide to stay, you can call what? The police department if it's in town, the sheriff's department if your home is in the county. With that in mind, the particular deputy sheriff or police officer, depending on the jurisdiction, will show up after a little bit of time, and then they will ask the person to leave. If they don't leave, they'll be arrested for criminal trespass. Now, it shows additional information in regard to the statute itself, in regard to activities. This statute's even used for people that enter into farmland, maybe just to look at the beautiful scenery, on a hike, or even what? Hunting. This is what's used to keep people off of farms or ranches, along with homes, or along with keeping them out of your garage or commercial building, or just off of your property, not coming into your yard. Now, let's try another one. Let's deal with theft. What's theft? Well, under common law, the terms were used larceny and embezzlement. This state put them both together and made a particular statute that's theft, and then you see the dash, it's receiving of stolen property. So they combined embezzlement with receiving of stolen property. This idea of larceny with the receiving of stolen property. So let's differentiate between what larceny and embezzlement relate to. Actually, we think of theft as kind of a stealing, so we could extend it even to a robbery, except this state hasn't combined that into theft because robbery is a higher level of offense when there's a person present. So it's force, threat of force, or just the presence of a person makes it a higher level offense. Why? Because the potential injury of the victim, so you could be punished for a longer time. So this state's legislature didn't combine robbery with larceny and embezzlement. So let's talk about what larceny is. Well, imagine someone's in a grocery store and they pick up some particular item and don't pay for it and put it in their pocket and leave with it. We say that's shoplifting. In this state, that's a theft. Okay? Or the idea that someone leaves something in their classroom when they go out, their laptop, a book, and another student steals it, right? No one's around, so it isn't a robbery, and there's no threat of force or force used, so that's a larceny. That's the old English term that's been included in this idea of theft. Then we have this idea of embezzlement. We normally think of individuals stealing money from their employer. Why? Because the money's entrusted to them. So let's imagine the person's a clerk, they're given $20 to pay for something, and they don't put it in the till, they put it in their pocket. They're stealing it. That's an embezzlement. An embezzlement also is writing checks off of your employer's account, and those checks you write to yourself and you're not entitled to those monies, that's an embezzlement. Taking your employer's goods, the chair, the table, the computer. That's embezzlement. What's the difference? It's entrusted to you. So there was a different time period to be punished if something was entrusted to you rather than the larceny aspect of stealing. So this state put them together because of technical defenses. What's a technical defense? Well, let's try this. Let's imagine that I'm having some difficulty with my projecting equipment. And I'll just make an example that's a little easier. 5 years ago, we still used overhead projectors. So you'd do the little bit of the plastic see-through stuff. It would copy the particular material, and you'd put it on a projector and you'd show the students. Well, if we wanted a projector in the room we were teaching in, here at Purdue, we had to contact our facilities people and tell them what room we wanted it in and what time we wanted it in and what course we were teaching to have it there. And then they would send us a follow-up email telling us that it would be there in a certain time period and that we could have it those times. And then if we didn't say for the whole semester, it'd only be for one day. So we'd have to put that down. And so they would also say the number that was put on this particular overhead projector, and it was entrusted to me. So it would be in the classroom for that time period, and that was entrusted to me. They would also say that if it isn't working correctly, contact facilities, and they then would fix or try to fix it. They said, do not go to another room and grab someone else's overhead projector. Why? Because it had been entrusted to other parties. So let's imagine I come into the room, I try to use the overhead projector just before class works and it doesn't work. I'm thinking, oh no, I want my students to see this. So I look through the different classrooms. There's one classroom where the professor hasn't shown up yet, so I take my broken one in. This is a hypothetical. And I put it where their overhead projector is supposed to be, and I take their overhead projector that works and bring it to my room. Now it has a different number on it. The one I bring to my room wasn't entrusted to me. And now, here's my hypothetical. Let's imagine at the end of class, after all the students are gone, I steal that overhead projector and take it, put it in my car. I've committed what? Under old common law, and many states still use this term, embezzlement. The media uses it all the time because it shows that it was entrusted to the individual. Now, what I really committed, though, was a larceny. Why? Because the one I took wasn't entrusted to me. So let's imagine that now the one's missing in the room, and I am charged with embezzlement. Did I embezzle that? No. And so once the trial starts, I explain to the jury what I did and that I didn't embezzle. I committed a larceny. Well, in most sovereigns, once the trial starts, the accusations, meaning what the government's charging me with, can't be changed. We have a few states like Florida that they can, but states like Indiana, no, you can't change what I've been charged with once the trial starts. So now the jury doesn't convict me of embezzlement because the definition doesn't fit. So now I'm free, even though I've stolen something. Can they charge me again? No, that's double jeopardy, illegal under the U.S. Constitution. I can't be charged twice and brought to trial for the same offense. Now there's exceptions if there's a hung jury or if I appeal, those type of things. So Indiana combined larceny and embezzlement together. And then they even put in receiving of stolen property. Why? Because sometimes the government has difficulty proving that you stole something. You just have the stolen property. So let's try an example with that. Let's imagine this watch. Let's imagine I bought it in northern Chicago, and it was hot, stolen. If a reasonable person thought this watch was stolen, now I have stolen property. I've received stolen property, and title never transfers to personal property that's stolen. So if I'm charged with this, convicted, this will go back to the particular owner if they can be found. Now, with that in mind, if I just have the stolen property, they're going to allege that I stole it, but it can't be proven. I didn't really. I'm just holding that. So some states, receiving a stolen property is a separate offense. In Indiana, they combine it. Why? So there won't be a technical defense. So it'll be easier to convict the individual of the particular offense. Now, if we look at the next particular statute that I wanted to use an example of, most states have this. Burglary, it's an old common law term. The old common law term under English law was the breaking and entering of a home at night with the intent to commit a crime. Okay? That's been changed. As you can see, Indiana has expanded it. A person who breaks and enters, okay, we'll define what breaking and entering is, the building. So it doesn't just have to be a home. And then structure of another with the intent to commit a felony. So the intent to steal something, the intent to murder someone, anything that's a felony, then commits burglary, a Class C felony. Remember, Class C is 2 to 8 years. However, if the offense is a Class B felony, if it's committed while armed with a deadly weapon. So what's a deadly weapon? A gun, a knife, some tools, even just to break into the structure could be considered a deadly weapon. Or if the building or structure is a dwelling. So it's a Class B, this aspect of 6 to 20 years if you have a deadly weapon, or no deadly weapon, but it's just a home, a dwelling, rather than a garage or a commercial building. Now look at how the offense, the time period a person's going to be incarcerated for, increases even more. It's a Class A felony if it results in either bodily injury or serious bodily injury to any person other than the defendant. So if they're breaking in and they cut themselves, that doesn't count. It's bodily injury or serious bodily injury to another, that moves it to 20 to 50 years that they can be incarcerated for. Now, why does it say bodily injury or serious bodily injury? Well, old statutes would say bodily injury, and some people would say, oh, well, minor injury, that's not severe enough. So what happens is the legislature wants to make sure that even a paper cut is serious enough. So bodily injury or serious bodily injury is all it takes. Now, I mentioned that I would get back to breaking and entering. So how do you break and enter? Well, you could break down the door and walk in. You could break out the window and move in. But the entering is just any part of you or some burglary tool that gets into the structure when or after you've committed the breaking. So the entering can be slight, or it can be going all the way in to the particular structure. Now, the breaking, that to me is the interesting part. If a door is wide open or a window is wide open, that's not a breaking. It's an entering, but then the person can only be charged with what? This aspect of criminal trespass. They have to break, which means break down the door, or simply unlock the door. Even if they've stolen a key, that works. Or the door isn't locked, they open the door, that's fine. Or if the door is partially open and they have to open it more, that by the courts is considered a breaking. So if they have to take a screen off of a window, that's a breaking. If they have to lift up the window and there's no screen on it, that's a breaking. If the window is open without any screen, no breaking. So with that in mind, it's just a criminal trespass. Now, if they steal something when they're inside, that's a theft in this sovereign. Now, one of my most favorite ones, this idea of a battery. Why is that one of my most favorite? Well, not that I've committed these, but we see them or hear about them happening all the time. So here's my example. Let's imagine that we have someone that allegedly committed a criminal battery. See, we don't even say criminal, but it's under criminal law. Why? Because under civil law, it's the injured individual trying to receive damages for the action. Under criminal law, we want to punish the individual that caused the particular injury. So, as you can see, it says a person who knowingly or intentionally, doesn't mean accidental, didn't just bump into him. It's not the idea of negligence. It's knowingly or intentionally touches another human being. How? Rude, insolent. Catch that, it doesn't say and, it says or, angry manner, commits battery. And then the initial one's a class B, and then we go down in which it can be more severe in regard to this aspect of punishment. It can be a D, felony, rather than just misdemeanors. So the first, looking at this, rude. What's rude? Well, let's imagine that it's an in-class exam. Students take it. The next class I hand back the exam. And let's imagine a student didn't get a good grade and they wad up the exam and they throw it and it hits me. Is that a battery? Well, did they knowingly or intentionally touch me? Well, they could do it with their hand, but it doesn't take a hand. It can. They didn't hit me with their hand. They didn't stab me with a knife. They didn't shoot me with a bullet. Well, the bullet's coming out of the gun, but that still can be a battery, right? Unless I die, then it's a form of murder, voluntary manslaughter, involuntary manslaughter if they were aiming at someone else, right? Risky activity. Okay. But in this instance, the idea of throwing the paper, it's an extension of ourself, just like the bullet would be. Is that rude to throw your old exam and hit your instructor? Yes. Now, it's also insolent. Insolent just means the status aspect. The idea that I do something that I shouldn't and touch my boss. My boss is at a higher level, I'm being insolent. Student, professors at a higher level, that instance, that could be insolent. So we have both. Now, it also might be angry. They might be upset when they threw it. Okay? So it could be all three, but it only takes one of them. So it could be just an angry issue. It doesn't have to be even rude what they did. Now, think about rude, though. We're in Indiana. I've lived in Washington and California for many years. California, things there that people do, I would consider rude. The people in the Midwest might consider rude. But things here, right, could be a little different. So if it was a trial in California and we use this rude aspect, some of the things that go on in California aren't considered rude because it's so common. Where in Indiana, some of the activity might be considered rude. So really, it's a determination by either the judge, if it's tried before a judge, or the jury. Now keep in mind, if it's a Class B misdemeanor, there will be no jury. The only time we get a jury is if we can be punished for a year or more in time. In this instance, a misdemeanor, Class B, we can only be held responsible for not more than 180 days, so we don't get a jury. Remember, a year or more, then we have the right to a jury. So it'd be tried before a judge. Now we move down a Class D, that's a half a year to 3 years, because we could be held responsible for more than a year. Now we have the right to a jury trial. And see how it reads? It says bodily injury. The other ones didn't require a bodily injury with a Class B. A Class A requires bodily injury, so we're getting more severe in regards to the aspect. So let's imagine an individual is being arrested by a police officer and they do what? They touch the officer in a rude, insolent, or angry manner. Well, if an officer's trying to arrest me and I simply touch him, that's being insolent. I try to push him away. Why? Because in this particular circumstance, they're at a higher level than I am as a lawyer or even as a professor. Okay? But by pushing them, that could be considered rude to push a police officer as they're trying to arrest you. And I most likely am angry. So again, it only takes one of those. And now I could be incarcerated for anywhere between a half a year to 3 years. Now, if you look down further, a class under number 2, a Class B says a person less than 13 years old that is touched, and we have this aspect that it's done by a person that's at least 18, so 18 or older. So if you have a sibling that is less than 13 years old and you touch them in a rude, insolent, or angry manner, that's a Class D felony. Well, I'm an adult, right? I'm 18 or older. If I had a child that was under the age of 13 and I spanked him, is that rude? Could be, depending on the circumstances. Was I angry when I did it? Most likely. Is it insolent? No, they're at a lower level than I am. But it could be rude, or if I was angry, then I've committed a battery, a Class D battery. Why? I'm at least 18 or older, and it was a child under the age of 13 that I spanked. So even with discipline types of activities, this is where it's pulled into play. Now, you can see that it talks about correction officers to protect individuals, the F aspect, in prison or jail, higher level of penalty if the particular alleged criminal or actual criminal, being convicted individual, touches the correction officer, right, rude, angry, or insolent manner. Also, the aspect of a victim that has been battered in the past. That's targeting primarily battered spouses. So if my wife has beat me in the past and has been convicted of a battery, and now she does it again, it's a higher level offense. Now, the one I really like is G, the school corporation. So with that in mind, remember I used the example of the student throwing the paper at me, okay? Just throwing the paper at me, or the exam. Well, the question is, under this definition, am I a school employee? Yes. Am I on school property or within 1,000 feet of school property? I'm on school property. So did this person do something either rude, insolent, or angry manner in touching me with that paper? Yes. So now it moves this particular battery from a Class B misdemeanor, which is not more than 180 days, to a Class D, which is a half a year to 3 years, just by throwing that paper and hitting me. Now, not so significant, but when I was an undergraduate, I was a school bus driver. I would drive in the mornings, take the kids to school, K through 12, and then pick them up in the late afternoon. I would take classes during the day in between that schedule, and that's what helped pay for my undergraduate degree, along with scholarships. So, well, and spending money is what the bus driving also paid for. So with that in mind, one instance I had with a junior high student, he'd thrown some paper out the window. And I saw it, and I told him not to do it again. He threw some more paper out the window. So I turn him into the principal. The principal, without telling me, suspends this individual, this junior high boy, for 2 weeks because he did this. Now, when I come to pick him up, now I grew up in the country, I was driving school bus in the country, so this is one farmhouse, no other houses around, and I see the stepfather of this boy and the little girl that's the boy's sister. I stop at the house, I open the door, the little girl gets on, and the stepfather says, "Fisher, get out of the bus, I'm gonna beat the crap out of you." Whoa. If he had came onto the bus, that school property, and started hitting me, that would be a Class D felony here in Indiana. I was in Washington State, so a little different, but did I get off the bus to let him hit me? No. What did I do? I closed the door and took off. But with that in mind, I always like these aspects of real life instances that happen. Now, look at how this can be a Class C if there's serious bodily injury. Okay, doesn't say just bodily injury, but serious bodily injury. The paper cut won't work in this instance. Or if someone's using a deadly weapon. So now it moves to 2 to 8 years that the person can be incarcerated here in Indiana. So the idea of why do we punish? In these instances, we're just taking a look at how these offenses have higher levels of punishment. So again, taking a look at felonies and misdemeanors, and in this sovereign, time periods. Again, remember, you're not going to be responsible for time periods. It's just to emphasize this idea of why do we punish. So what I wanted to also do is to let you take a look at this particular article. Talks about a person getting 425 years. Why are they getting 425 years? Well, They killed a number of people, children and adults. So the idea of 45 to 65 years here in Indiana, that could be for one individual. So now we can add all of these time periods together and keep that person in prison for a longer time period. To me, that's interesting. Why is it interesting? Well, in Indiana, for every day a person is good, meaning they don't do something wrong against the rules, then they get 1 day off for every day they're good. So if a person has a sentence of 8 years and they don't cause any problems in prison, they can get off in 4 years. Okay? The idea is an incentive to have these individuals do what? Be better individuals in prison. So if you have a person that's sentenced to 425 years, why do we have that long time period? Well, to scare others, right? Remember, why do we punish? A deterrence, but also to make sure that he never gets out of prison. And even if he's good, he still will have to serve 212 and a half years. Won't live that long. So it isn't going to make him be a model prisoner. Just doesn't work in regard to the incentive. Now I'm trying to make this one a little smaller so I can get it on the full screen, but I'm having some difficulty with that. There. Now, with that in mind, attempted murder. Well, I like to talk about attempts, not necessarily murder, but you hear about things like attempted burglary, meaning they didn't get into the structure. Even attempted murder, the person doesn't die. Or attempted robbery, right? With those things in mind, we think about attempts. Most states punish attempts at a lower level than successful crimes. That makes sense, trying to not make them complete the particular crime. But let's imagine someone's trying to break into a home and then they decide against it. It's an attempted burglary of a dwelling, but it isn't a burglary. So most sovereigns, a lower level offense. In this sovereign, no. It's this moral aspect. You attempted to do it, so you're going to be punished just the same as if you were a successful criminal. So just because you're not successful, we're not going to reduce the penalty for the particular activity. So I always think about attempted murder. Ooh, that's not a good sign, because they have the same amount of time they would spend in prison for attempting to kill someone versus killing them. So it might encourage this criminal to actually complete the particular activity, to kill the individual, if there's the logic of knowing what the penalties are. Now, another aspect of a thing that isn't logical in regard, at least in my mind, in regards to criminal law, deals with this theft. Charges filed against a local person. So with that in mind, let's imagine someone steals thousands of dollars. And let's imagine they steal let's just say $90,000. Well, if they steal $90,000 with just one activity, let's use the idea of embezzlement. They write themselves a check from their company fund. They're not going to normally do it right to themselves. They'll make up a fictitious organization, company, write it to that company. Okay? And now let's imagine they're convicted of that $90,000 embezzlement. Indiana, it's called a theft. What are they going to be responsible for? Well, a theft. Half a year to 3 years max. Well, let's imagine we have this person that in this particular article has allegedly committed 28 thefts. So let's say they're convicted of it. How long could they be sentenced for? Oh, you see my little adding up there? 14 to 84 years. So they could have stolen the same amount of money, and rather than just having a sentence of a half year to 3 years, they have 14 years to 84 years. Why? Because we're adding the Class D felony. So the range is between 14 to 84 versus a half year to 3 years. Do most criminals know what the punishment will be? Absolutely not. Now, here's another aspect of embezzlement. The state audit shows $90,000 missing. Well, in this state, again, we call it a theft. Now, the idea of embezzlement, larceny, Indiana, we call a theft. Robbery is just the idea in the presence of another individual, or the force used, or even just threat of force to try to get those particular monies or assets. Now, another aspect with criminal law is this idea of sentencing guidelines. That deals with what we saw in regard to how a Class D felony is a half year to 3 years, or a Class C 2 years to 8 years, or a Class B 6 years to 20 years, or a Class A felony 20 years to 50 years, or a murder 45 years to 65 years. Those are guidelines, is what we say. Okay? It's the range that the judge can choose. Well, this particular article shows a federal judge, so they're not going to use Indiana ranges, but a federal judge that is the trial level court gives a sentence, and the appeals level court says that they were too lenient. They went outside, meaning they went lower than the guidelines. And so this particular judge is what we would call reprimanded, meaning told that they shouldn't be so lenient, that they should comply with the sentencing guidelines. Now, guidelines I always think of as voluntary, but in most sovereigns and in the federal government, they have to stay within the particular ranges. There can be exceptions, but then the appeals court gets to look at that to decide if they're going to go along with one of those exceptions. That's how it works. Now keep in mind, when we talked about why do we punish, the idea of deterrence or this idea of restraint, the idea of these felonies, misdemeanors, the time period that a party will serve for their particular offense in this sovereign. Now again, the idea of why do we punish, what's the justification, that idea of reformation, deterrence, restraint, or retribution. Those particular types of rationale. Now, keep in mind, when we're talking about common law, we've mentioned exceptions with Indiana. Some states will have similar laws to Indiana, some will be a little bit different. The principles are the same, but with modifications. Now, some of us travel between different states, different countries. We have to look at what that sovereign deals with, not just the sovereign where it's our residence.